Yeah, I'll put some more. I just need to twist this one around.
Run the test.
Yes.
Mic test, mic test, mic test. You getting it?
Try again.
Mic test, mic test. Still nothing?
No, not getting this.
I'm going to tell her we'll work on some more after lunch.
Is there sound system?
It's not as long, but
I worry a little bit about just that kind of that's kind of the crowd. That's the crowd.
All rise. Circuit Court is back in session.
Few cases I need to know here.
All right, Your Honor, I will try to speed things up a little bit. I don't think there's much left to do. On the specific issue of commercial purpose, where Mr. Vogt began is he said, you don't have to worry about a chilling effect from permitting liability in this case because most people don't publish a sex tape. The fact that we published a sex tape, or part of a sex tape, has nothing to do with the right of publicity analysis, right? The fact that we published explicit explicit material, some of it, that is relevant to privacy claims, that's relevant to intentional infliction of emotional stress. It's not relevant to right of publicity, which just has to do with how you're using the name and likeness. If my children, do a lemonade stand and they put a poster with Mr. Blair's face on it, that's a commercial purpose, right? They're endorsing their lemonade stand with his name and likeness, but it'd be so cute, I'm sure he would be fine with it. It wouldn't be offensive, but it would nonetheless be a violation of the tort. It has to do with the manner of use, not whether it's explicit or not. The second point is just that in recounting the testimony, what Mr. Vogt did is said, look, we had testimony or evidence that Gawker publishes articles about well-known figures, people like to read them, they get more uniques that way, and that's good for their business. They benefit from that. We agree that uniques are part of Gawker's business model. We disagree with Anderson's use of them, but we'll get to that later. But we agree that's part of the business model. But simply benefiting from using someone's name or likeness isn't a commercial purpose. That is as clear as day in the law. That was initially in the jury instructions. We took it out because it was wrong. That's not the law. Simply benefiting isn't enough. And that's the only way that they have. The only thing different between their theory and the theory just that benefiting is enough is they have to sort of play on words about the word advertising, right? The standard is commercial advertising purpose, and they say, well, they did this to get advertising dollars, therefore we're in the game. That's not what commercial advertising purpose means in this context. So that's all I have to say on that, Your Honor. Do you have any questions?
No.
All right, so moving on to punitive damages. We've been over this territory before, so we'll be very brief, I hope. As you know, Your Honor, the testimony at trial was controverted, that every single Gawker witness testified that they believed at the time of publication that the publication was newsworthy. And it's not disputed that if that's true, right, if that was really their belief, then there can't be punitive damages, right? You need intentional misconduct for punitive damages. And so in order to show an entitlement to punitive damages, it has to be the case that by clear and convincing evidence, the jury was permitted to disbelieve every word of all of that testimony. That's where you have to get for there to be punitive damages. And if you look, Your Honor, at the Toffaloni 3 decision, I don't think they can get there. And this is one of the cases we provided Your Honor with. The Toffaloni 3 decision explains very clearly that even though the Toffaloni court thought what Hustler published wasn't newsworthy, there couldn't be punitive damages because there was not clear and convincing evidence that they didn't think it was newsworthy. And it focused on 4 factors, 3 of which are present here in spades. The first factor is uncontroverted testimony that they believed was newsworthy at the time. We have that here. The second factor is, in the Toffaloni 2 case, just like in our case, after the plaintiff complained about the publication and sent off a cease and desist letter, counsel for the publisher wrote a lengthy response outlining the reasons why they believed it was newsworthy. That was the second factor. The third factor is, at least for our case, I think the most revealing. If you look at the second to last paragraph in Toffaloni 2, the court says as follows. The strongest evidence supporting our conclusion that this mistake on LFP's part, that's the publisher, was reasonable is the fact that the district court in this case initially dismissed Toffoli's case because the court agreed with LFP that the photographs met the newsworthiness exception. Although that decision of the district court was ultimately reversed in Hustler 1, that's what we call Toffoli 1, we do not believe that publishers should be held to a higher standard than that of the learned district judge. And I think that's dispositive on the punitive damages issue here, right? You had Judge Whitmore in 2 published decisions, the second DCA in 1 published decision, saying, we've looked at this publication, and on its face, it seems newsworthy or seems to relate to a matter of public concern. Now, there's a debate about what we do with that in a legal sense, whether that's binding on this court, whether it's law in the case, whether it's precedent. We had that debate earlier. But it means that judges who we have to presume were acting in good faith looked at this thing and said, we think it's newsworthy. That's our assessment. And I think based on that fact, the jury just couldn't take the testimony from the Gawker witness and say, it's just incredible. We can't believe that. It's too implausible that anyone would ever think this related to a matter of public concern, because we have judges that we have to believe were acting in good faith who came to the same conclusion. So I think that's dispositive, and I think if the punitive damages award stands, I think they're going to have a very hard time on appeal making that pitch to the second DCA, saying essentially, no one could really have believed this related to a matter of public concern. The last factor in Toffoli is advice of counsel, and there is a distinction, right? In our case, in Toffoli, they testified about the content of the advice of counsel. In this case, that didn't happen, but that's not dispositive in Toffoli. We meet 3 of the 4 factors, and the last factor, which the court called the strongest argument, the most important factor, here we have it in spades. So that's the argument on punitive damages, Your Honor.
And Your Honor, I haven't said this yet. It's obviously in the papers, but we're here after a jury verdict, which is entitled in this instance, the issues we're talking about now, to extraordinary deference. The Toffoli case, most of that argument was based on very distinguishable from what we have here, even in the context of the 4 factors. The first thing that Mr. Safier said was there was uncontroverted testimony that they believed that this was newsworthy. Well, that self-serving testimony that consisted of these people saying, I thought it was newsworthy, is what the jury rejected. And they didn't actually explain why they thought it was newsworthy. In fact, the only evidence that you had as to the arguments that the Gawker defendants argued that it was newsworthy, we've already seen today. Mr. Delario testified, point blank, that none of those were the reasons that he published. So what that demonstrates, Judge, is that from day one, they knew this was not newsworthy. From day one, they knew that the only reason he was putting this up was to put it up, was to put out a sex tape. They know that's not newsworthy. They know that's not protected. And we know that they know that because they've said it. Numerous exhibits were admitted at trial, Judge, for this specific purpose, knowledge and intent. When Tumblr refused to take down pictures of people that were secretly recorded in a bathroom, naked, they called it wrong. They called it an invasion of privacy. They did the same thing when people hacked nude photos of celebrities on the cloud. They said those people were being victimized. They knew exactly what they were doing. They knew it was wrong. They knew it was an invasion of privacy. They knew it would cause emotional distress. They knew it would cause harm, and they did not care. There was no good faith reliance on any determination that what they were doing was lawful. The strongest evidence that they talk about in the Toffoli case being the prior decisions of the district court dismissing the case. Well, there's no analysis. There's no explanation as to why that was actually done. And there's certainly no comparison of the actual facts at trial in this case and what they showed. In fact, again, they showed the exact opposite. When we sat here earlier today and went through all of the reasons why the Second District Court of Appeal thought that this was newsworthy, and you compare them to what Mr. Delario said under oath on the stand in front of the jury, they're irreconcilable. Makes this case completely distinguishable from Toffaloni. Very importantly, Judge, the Toffaloni case said that there was no bad faith present for the purposes of punitive damages. They talked in detail about the advice of counsel. In that case, they actually talked about what their attorneys told them. They actually consulted their attorneys multiple times. They actually had a good faith belief that they thought that they could publish this based on the advice of counsel that was revealed, as well as the fact that this woman was deceased. Mr. Benoit's wife was deceased. Well, here, they refuse to tell us what their lawyers told them. It's completely different. For all we knew, for all the jury knew, their lawyers could have told them, don't do this. You're crazy. Don't put up a sex tape. But they made the choice not to present that evidence. That was their choice. That's a common theme that you're going to see in a lot of the arguments today, and it's a common theme in a lot of the arguments in our papers, is that a majority of the things that they're complaining about here, a majority of the things that they said were wrong with this trial, a majority of the things that they say that we did wrong and that you did wrong and that the jury did wrong were actually their own choices that they made. They just don't want to deal with the consequences of it. This is another perfect example. They chose not to tell the jury what the lawyers told them. They could have, but they didn't. That was their choice. They have to live with it. Just like the choice they made, despite knowing that this was secretly recorded, despite knowing that Mr. Valea didn't want it out, despite knowing what the contents of this were, despite knowing, based on their own prior articles, that putting something like this out on the internet was wrong and an invasion of privacy, they did it anyway. That is precisely why the jury came back and found that they clearly and convincingly had an intent to harm and that they did not have a good faith reliance on anything that they did in this case.
As to the prior Gawker publications about Tumblr and about others of, where Gawker writers are criticizing the publication of material involving nudity, it's never been anyone's position at Gawker that anything you publish involving nudity is okay. Sometimes it's invasion of privacy, sometimes it isn't. The testimony was that what they published here was newsworthy. That was uncontroverted. And again, I'm just going to go back to where I ended, which is that it's just, if this is one of the issues we have to take on appeal, it's just going to be a very hard sell for them to the second DCA to say, look, you looked at this, you thought it was newsworthy, but the jury was permitted to disbelieve the uncontroverted testimony of all your witnesses under clear and convincing standard to the effect that they thought it was newsworthy too. I don't know how they get there. They're very good lawyers. They might make it, but it strikes me as a tough lift. What? I'm sorry. They are good lawyers. I mean that.
I don't know. I generally just don't think it's very professional since we have a bunch of interns that are here.
Understood.
I don't think it's really professional to be attacking the other side's. Yes, make distinctions.
Fair enough.
But criticizing the other lawyers just isn't a good practice.
I apologize, Your Honor. I did not mean that in that spirit. The last point has to do with the last issue, unless Your Honor has any questions. Okay, the last issue has to do with personal liability for Nick Denton. I just want to be very brief on this. It's undisputed that for Nick Denton to be personally liable, he had to have personally participated in the publication. As I read their opposition, they have three arguments. One, they say he approved of the publication before publishing. Two, he has this broader publishing philosophy that led somehow to the publication. And third, he ratified it after the fact. I don't think any of those arguments get you there. The first approval, the testimony was undisputed that prior to publication, he had never read the publication. Prior to publication, he had never watched the video excerpts. He had some vague awareness that A.J. Delaire was going to publish something involving Hulk Hogan sex tapes. He didn't know what it was. That's not publication, right? He would have to have some sense of what actually was going to be published to have participated in the publication. The second point is the publishing philosophy point. That's really a vicarious liability argument. The argument is basically Mr. Denton set in motion a series of policies that then convinced A.J. Delaire that what he was doing with the explicit approval of Nick Denton, even though he didn't have that, because there wasn't that conversation about the content of what was published. That's a vicarious liability theory. That's a theory against Gawker as a company. It's not a theory against anyone personally. You don't get personal liability based on a vicarious theory. And the final point is ratification. And this is very straightforward. Florida statute 770.07 makes clear that Florida follows what is called the single publication rule, under which a claim accrues at the moment of publication. That's when the statute of limitations begins to run. It doesn't restart when you simply don't take something down. After the fact, ratification of something by refusing to take it down isn't a tort and can't be a basis for liability. And that's, unless Your Honor has any questions, that's a sum total on that issue. Thank you, Your Honor.
One of the things that we did to sort of benefit the court was, included within the materials we sent you, was a detailed statement of facts with record cites and cites the evidence. And there is a section in there specifically on Mr. Denton's personal participation in the publication of the video. I'm not going to go over all of it, but we lay out painstakingly in detail everything that he did. He ratified, he approved, he set in motion everything that happened in this case. He knew before this video was posted that a sex video was going to be posted. He knew. He said that. Now, what you saw at trial was Mr. Delaire trying to take the fall from Mr. Denton. And the jury saw right through that. They saw them give conflicting statements about what happened on this fire escape conversation. Mr. Denton claimed it never happened. Then he said it did happen. And Mr. Delaire said it didn't happen. When he had deposition testimony that conflicted with that. It makes it clear that he knew. He knew. He knew exactly what was going to happen. And to suggest that somehow he didn't know exactly what was going on just defies logic and common sense. He could have stopped it before it happened, and he didn't. Why didn't he? Well, we have ample evidence as to why he didn't. And one of the critical things that Mr. Delaire admitted at trial was he had a quote that he acknowledged. He said, quote, "The reality is I work for Nick Denton, the founder of Deadspin's parent company, Gawker, who doesn't adhere to those," referring to ethical rules. "If I work somewhere else, would I do that? Probably not. But people want me to adhere to the rules of their job instead of what I'm asked to do here." What he is asked to do by Nick Denton, which is yellow journalism. What he is asked to do by Nick Denton, which is to be a hustler for provocative materials. One of the other important facts that came out during the course of the trial for Mr. Denton is that there was a dearth of news for 5 months leading up to the publication of this video. You mean to tell me that the CEO of a website in the middle of a 5-month drought for news stories has a conversation with his editor-in-chief about something as significant as a sex tape, and he has no clue? It wasn't believable. The jury didn't believe it, and they shouldn't have believed it. You know, Mr. Delaire followed Mr. Denton's rules. That's what he did. He did what he was instructed to do. Mr. Denton also personally received a plea from Mr. Houston. Very basic plea for human decency, which, by the way, is one of the things that Toffoloni talks about taking into consideration, contrary to some of the arguments you're going to hear today. And he said, look, just take down the video. Leave your story up. Take down the video. That's it. And Denton said no. He could have stopped it right there, but he didn't. And what is incredible about that is one of the things that the defense are actually arguing is that, well, he hadn't even seen the video. So he's going to make a decision not to pull a video when he acknowledges to the jury in response to their own question that if it's gratuitous, it's not protected by the First Amendment, but he's not even going to bother to look at it. When he rejects Mr. Houston's plea on behalf of Mr. Galea for basic human decency. It's willful blindness. It's a very simple concept. And it's clear that that's what happened here with respect to that plea. We think he knew exactly what was happening. It's clear that he participated. Those facts are laid out in detail in our statement of facts and the jury's award against him. And there's specific finding, Judge. They made a specific finding that he personally participated in this. And they certainly have not stated any position in their papers or in court today that would justify overturning that finding by the jury.
Very briefly, Your Honor. Mr. Vogt said that Mr. Denton was willfully blind either prior to publication or after publication. Willful blindness isn't a theory of liability for an intentional tort. It's not a negligence case. That can't get you there. I just want to just one more point. I've always been confused by this idea, but I think Mr. Vogt said that A.J. Delario took the fall for Nick Denton, therefore the jury was permitted to disbelieve A.J. Delario's testimony about Nick Denton's involvement in the publication. But we're moving for a directed verdict based on Denton's testimony. We're not saying, you should believe Delario over Denton. We're saying Denton's testimony was that he played no role in the publication. He probably had a conversation with A.J. Delario before publication. He didn't know what specifically was being published. And Mr. Vogt cited their factual findings. They explicitly say in those factual findings, Nick Denton didn't watch the video prior to publication. He didn't read the article prior to publication. And Mr. Vogt criticized him for that. And he may well be subject to criticism for that. That may be a decent thing to criticize him for. But as a matter of law, it establishes, I think, that he didn't publish the piece, which is the only basis for liability here. And as for all the other grounds, Your Honor, that we move for directed verdict, or for J&OV, we would just rest on our written papers. Thank you, Your Honor.
Thank you very much. The court's going to deny the defendant's motion for judgment, notwithstanding the verdict. Therefore, for arguments, I'll put something in there ahead of time so I can read it. Next, motion for new trial or alternative remainder. Mr. Bergeron.
Morning, Your Honor. The first ground, obviously, for asking for a new trial is the same items that were in our J&OV motion, both as in our papers and that Mr. Saphir talked about this morning. Given your ruling on the J&OV motion, I'm going to pass on repeating all of those arguments and move to the things that are different than that, if that would be all right with Your Honor. And really, I think these can be treated together. There are a number of grounds raised in our papers about why a new trial here is warranted. And with respect to much of this, because the papers are lengthy, I think, in particular, the plaintiff's opposition ran to some more than 70 pages. I will try to focus on a few things, and again, as Mr. Saphir did, rest on our papers with respect to the rest, which I know Your Honor mentioned that you've read, consistent with your practice throughout the case. So we appreciate that very much. I know it's been a lot of paper. With respect to the new trial, the thing I really want to focus on is this notion that the jury acted with passion and prejudice and not just applying the law to the facts before it. And really the thing here is even assuming that they found and were entitled to find that what Gawker did was unlawful, the size of the verdict itself reflects that they were acting with passion and prejudice. We learned in first-year torts, where you'll learn a lot of Latin if you haven't studied it before, various phrases. One of them that comes to mind for this is res ipsa loquitur, right? The thing speaks for itself, right? The magnitude of this judgment, which so far exceeds any other judgment against any other media defendant anywhere that we are aware of, including something like 8 times what it is in the largest one in the state of Florida before it was reversed, tells us that we are not acting in the realm of reason, that we are operating in the realm of passion. You know, Mr. Vogt was speaking earlier that the jury was offended by what they saw here. And it is clear from the magnitude of what they did here, both with respect to compensatory damages and punitive damages. I know their point is, there was only $25 million in punitive damages, and had we not said what we said, then it would have been larger. I'm not sure that that's true, given the formulas that we have to deal with, but both in terms of not bankrupting the defendant and in terms of the relationship between compensatories and punitives and taking them together. But the size of the verdict is really the thing that we would just focus on in terms of saying that this really is borne out by passion and prejudice. And I don't say that to demean the seriousness with which the jurors took this, but I think that they went back, they deliberated for a trial of this length, a fairly short amount of time, and rang up some very, very, very large numbers. And let me explain, because I think that, and the reason we filed these together as one is because the new trial and the remittitor arguments go together in large measure in this way with respect to the damages. And the remittitor, in asking you to remit the damages to a substantially lower amount, really explains why we believe that the new trial is also warranted because of the overwhelming passion and prejudice that led to the huge amount. So the remitter, we start with the statute that is the remitter statute, as you well know, and once a remitter motion is made, Your Honor has a statutory obligation to review the amounts awarded in damages, and I really think that falls into 2 categories. One is to ask the question, is the jury awarding something that does not comport with the evidence, right? And the second is to say, to bring whatever award that the jury awards into a rule of reason in line with other judgments in other cases, which the jury doesn't have before it, and that's the thing that puts that takes an individual case and puts it in a system of justice, right? So those are sort of the 2 things that you're being asked to do, and that review by this is from the Section 6 of the statute. It's recognized by the legislature that a review by the courts in accordance with the standards set forth in this section provides an additional element of soundness and logic to our judicial system and is in the best interests of the citizens of this state. So this is where we start. There are 3 components to the jury award, and I would like to go through each of them individually if I could. The first is I think I'll start, if I could, with the $60 million that was awarded in emotional distress damages. And here there are really 2 points to make. Okay, the first is that this was a case which the plaintiff, as Your Honor will recall, way back when in our very first discovery hearing in October of 2013, made an election to say, I'm only seeking garden variety emotional distress. And he did that so that there would be no discovery into his medical, psychiatric, or psychological records saying, I didn't seek any treatment, and all I'm going to seek is garden variety emotional distress. There is Florida law on what that means in terms of damages, and we asked at some point that this should be a jury instruction, and the plaintiff said, well, if there's an issue, it can be sorted out after. So what we do here is excuse me, and we lay this out in our motion, that the damages for garden variety emotional distress, as opposed to proven emotional distress where you come in and say, I am suffering from this psychiatric illness and I'm going to need this kind of treatment that's going to cost X amounts of dollars, may debilitate me from going to work with Y amount of dollars, right? That's standard proof of damages. Garden variety is something where you don't have that. And the Florida courts basically have said that they can't be more than $100,000 and typically are more in the $10,000 to $50,000 range. Not here we are at $60 million. And just to give you some of the cases that we've given you copies of these in the binders. In the Ernie Hare Ford case, the second DCA held that the trial court abused its discretion in not remitting what was there, a $3.5 million award in a garden variety case. Again, not $60 million. They started at $3.5 million, and the court remanded and said, in such cases, courts have been reluctant to uphold damages awards which exceed six figures. That's where we come up with this $100,000 number. Then there's the City of Hollywood versus Hogan. Although it uses the words Hollywood and Hogan, I don't think that the plaintiff was involved in this case. The fourth DCA held that a $1 million emotional distress award was excessive where only garden variety distress was proven, noting that the typical award for garden variety distress, this is their word typical, should be in the range of $5,000 to $30,000, right? And then in the Stone case, the Middle District of Florida, looking to Florida law, had a jury award before it of $200,000 in compensatory damages for emotional distress and suffering for garden variety, and they found that $50,000 was the maximum recoverable. Now, I say this to you because I believe that if we were here back in October of 2013, and the plaintiff came in and said, Your Honor, I would like to limit my claim to garden variety emotional distress, and I would like to have no discovery into other possible causes of my emotional distress from my medical records, my psychiatric records, my psychological records, from other cases that I might have asked for emotional distress damages in, etc. Things that we asked for discovery about and we were not able to get. The idea that if he had said at that time, but I would still like to be able to get a jury award of $60 million, I think Your Honor would have said, I think at that point you're entitled to discovery, and you said to the plaintiff's counsel, I'm going to accept your limitation, but it will have consequences for you later on down the road in terms of what you're able to recover. Right? You were here, I was here, this is what happened. So we do not have a single case in which we have garden variety emotional distress in anywhere near that magnitude. Now, they've cited a couple of cases from out of state, one, if I'm recalling, from Oregon and one from somewhere else, where, although there was no discussion, the garden variety emotional distress, and this was a claim against the IRS, and I would suspect there's probably an IRS exception for emotional distress that you get a higher number. But that case was a $5 million award, and that is the largest case that the plaintiff has put forward in terms of damages for garden variety emotional distress. And we would respectfully submit to you that where the proof was here, and the proof was consistent with the claim of garden variety emotional distress, we basically had plaintiff's own testimony, and it was limited to plaintiff's own testimony about loss of sleep, loss of appetite. These are the kinds of things the courts say, yes, you can talk about in terms of a garden variety emotional distress claim. We had the claim from, we had testimony from his publicist, Jules Wortman, who said he didn't seem like himself and had one episode where he became teary with Kathy Lee Gifford on the set of the Today Show. And again, that's the kind of thing that's consistent with that kind of proof, not psychiatric, not loss of income as a result of debilitating psychiatric illness or whatever. So the first point on that is that we believe that $60 million cannot stand, both principally because it is subject to that limitation. But even if you did not have that limitation, and this brings me to the second point about the emotional distress award, is that you basically have a situation where at $60 million, even if you had actual proof, not just testimony about in the garden variety nature, right, which we don't have here, but even if you had that, you would look at other cases and you would say there is no other case where a plaintiff is getting a $60 million award for any kind of emotional stress, much less garden variety emotional distress. And here, they basically have given us, snippets of cases, right? So we have a case where they cite and they say a large damage award by itself is not necessarily indicative of excessiveness or impropriety, right? And they're citing a case called Zambrano from the 4th DCA. But they leave out the next part of the quote, right? Where it's, if the thing is so large, then you have to reduce it, right? That's what the rest of the quote says. And in that case, they reduced a $75,000 compensatory damage and a $100,000 punitive damages, we'll get to punitives in a minute, to roughly $7,000 each, right? So we're really talking about different things. Now, and if you look at the cases, right, we do not have cases, and look, this is what they're really saying. What they're saying is, well, this case is not like other cases, right? And of course, every case is different. Every case is different. But the human experience of what it means to suffer injury for emotional distress does have some common and significant overlap from case to case. And so you might have a case where, as we do, we have the Kammer case where the $60 million is 24 times the amount awarded in that case. That's a fourth DCA case. And the parents in that case, it was parents who brought this claim, and they witnessed, this is disturbing facts, but the parents witnessed their child's skull being crushed using a vacuum extractor during labor and delivery. That's a horrible experience for anybody who has, for anybody, but if you have children, that's horrifying. And the punitive damages award there, again, 24 times, this one's 24 times that one. In the Gladman case, that's a 3rd DCA case, the $60 million we have in this case is 15 times the amount judged to be so excessive as to have been a product of passion and emotion. And there the facts involve the death of a child as the result of a medical misdiagnosis, right? Then we have the Ailes case, that's AILLS, which is 7.5 times, this amount is 7.5 times that amount, and the plaintiff there suffered a permanent and painful disfigurement as the result of medical malpractice, basically living the rest of their life that way. So I would respectfully submit that even without, and in those cases they're not claiming garden variety, they're actually putting on proof of a different nature, but even if we were to go to remove garden variety from it, we're at a level where you just don't have cases where people are recovering $60 million for emotional distress, and that amount, and this is where we look at other jury verdicts and we say, and we look at what other courts have said is an appropriate amount, and you bring that into reason. The jury doesn't have these other cases as benchmarks, they only have this case, so that's really the province of the court. So that then brings me to the economic damages. And the 2nd DCA applies a fairly stricter standard for the review of economic damages, because there's actually proof. It's not something where it's a little loosier-goosier than like it is with emotional distress damages. And this is not rocket science, but there's the basic rule that says the court cannot allow the jury to award more damages than what is reasonably supported by the evidence. Now, the best example of this, Your Honor, is that the jury, Mr. Turkel, we were upstairs. I was going to wave at the jury, but they were on that side in the upstairs courtroom. They showed at the end of the case the jury form, which they had filled out the way they wanted the jury to fill it out. And the total amount of economic damages that they sought, which they claimed they had proved The maximum amount that they approved from their two experts in their sort of two different models was $50,378,342.95. They had that was their proof that they said was their proof down to the penny and 95 cents, right? The jury, right, awarded $55 million, right? So we know that even if you credit plaintiffs, if they basically got everything that they asked for, the jury awarded another $4.7 million, or to be exact, $4,621,657.05. And they exceeded that amount. We know under settled DCA precedent, you can't give the you can't award to the plaintiff more damages for economic damages than what was proven. So at a minimum, and I realize we're talking about large amounts, so this is, I'm asking for other remitter besides this, but at a minimum, that $4.6 million and change needs to come off the award because it clearly exceeded the proof. Now, then you get to the two things that make up the $50.3 million number, which is what they say they proved, and you really have two things. And I'm going to talk about each of them separately, and then I want to explain why you can't get both at the end, but it'll probably make sense to explain why each one separately, because it'll put that in perspective. So we have first this theory of $4.95 a view, right? Now, what they said to the jury was that I'm entitled for each person who saw the video, right? And there's a lot of evidence about who saw it, who didn't see it, whether the numbers were reliable, and I'm not going to belabor that point, just rely on what we said in our papers. But even assuming that this quantity of people saw the video, right, that I want to get $4.95. And they described that at the trial as the value of a business opportunity that Belayel lost when someone else published excerpts from the sex tape. Use the words business opportunity, and it dovetails with the right of publicity claim that Mr. Saphir and Mr. Vogt were talking to you about earlier. And I should say that, you know, I might add to this that in discovery we also asked, okay, you want right of publicity damages, you want the loss of this business opportunity, could you tell us, please, how much you license your name and likeness for other purposes, right? What are the value of those publicity rights? And the plaintiff refused to do that. So we were a little bit limited in what we could do to rebut this, but be that as it may, we have this business opportunity, and that was what he had to prove. This is how much he would have made if he had chosen to commercialize this. And he said, of course, I didn't choose to commercialize this. And he's, you know, now for the first time, he didn't plead it, he didn't argue it in any motion, he didn't argue it to the jury, but he's now saying, I want to use a conversion theory, but that's not really what we're here for. We're here talking about this business opportunity. But if you do that and you assume that's what he had to do, he didn't actually prove that's what he would have gotten, right? What he did, where we come up with this $4.95 number, is we say, look, when you go to a whole library of complete celebrity sex tapes, if you want 4 days of access to that whole library of complete celebrity sex tapes, you have to pay, as the person getting access, $4.95. Now, there was testimony put in the record that if you want to see a snippet of a celebrity sex tape, you can do that for free, you know, through arrangements between the place that sells them and another place, in the hopes that you'll go and then, you know, pay for the full version. So that's more analogous to what we have here, because we have a minute and 41 seconds, 9 seconds of sex. We don't have a complete celebrity sex tape in this case. But the $4.95 is problematic, really, and this measure is problematic in two ways. One is, it does not tell you, here's what I, Terry Bollea or Hulk Hogan, would have gotten if I had licensed my tape to this library, because the library is not paying $4.95 per view to all of these different celebrities, and if it were, it'd be quickly out of business, right? It's paying some portion of it. Maybe it's a flat fee, maybe it's a per view royalty, we don't know. The plaintiff had plenty of opportunity to gather that evidence, to put it into the record, did not do so. And the only evidence that was in the record was that you can get a snippet of this for free, right? And you might say, right, and then it begs the question, which this is whether if people would pay $4.95 to watch this minute and 41 seconds of video, right? That's the second issue. Even assuming that that was his share, right? The first part is that he would get less than that, and we don't have any proof on that. But even assuming that you could get $4.95, would all those people pay? Now, he says, I'm entitled to all of that because I'm now invoking for the first time this conversion theory, but let's just look at the proof that we have, okay? And what we have here is expert testimony from his expert saying, we asked how many people would have paid for this, and he said, I have no idea, but, right, typically in e-commerce, right, this is online commerce, in e-commerce, the conversion rate, which is how many people that you, when you ask them to do something for free, would actually pay for it, is in the neighborhood of 1.5%, right? So you take, if you're going to do this, you take the number of viewers and you say, we take 1.5% of that because if we're crediting his expert, right, not our expert, we're crediting his expert that says that's how many people would have paid for this. So if you're going to take that number, it's probably less than $4.95, probably a lot less, but even if you credit the $4.95 and you take that 1.5%, you end up with 105,858 viewers who would have paid. You multiply that times $4.95, you get to $525,000, not 35.4 million, which is where he comes out, right? Because I think in real life, if he had taken this business opportunity, I mean, just as common sense, if he had taken this business opportunity and said, look, I want to go and market 90 seconds or 100 seconds of a sex tape, I don't think anybody really would believe that you could get $35.4 million from doing that. And I think the jury was, the reason why this doesn't comport with the evidence is that it basically took, even assuming it accredited Mr. Shun, who's their expert's testimony, and said, I'll give you the $4.95, and I'll assume that people would have paid you that full amount, and I assume that some number of people would pay. Then you got to give the guy. Then you have to credit his other testimony, which says that's 1.5%. Now our testimony, we had different testimony, where we had a fellow named Goldenberg, who comes from a porn company, who said that. Where we had this testimony, where we had 105 million views of Kim Kardashian, and I would respectfully submit, and I mean no offense to Mr. Boulea, but that probably in the sex tape universe, Kim Kardashian might even be a bigger draw than Hulk Hogan. But let's just say 105 million views of Kim Kardashian resulted in only 15,000 subscriptions to a free channel, right? Now that's free. They're not paying, and that's a conversion rate of 0.01%, right? Much smaller than what their expert's saying. Now, I realize that at this stage, we have to say, okay, the jury could have credited their witness and not our witness. But so I'm prepared to say, okay, it's not 0.01%, even though I think that person actually has a lot more expertise in this area than somebody who said, I don't really know, that's not my area. But even if we credit their guy, that's where you left. And so that's why when we put in our papers, we think that if you're going to adopt this theory and you're going to do it the way their guy says, you got to do that, and then it comports with the evidence, and you get to economic damages of what's still a lot of money, $525,000 for this theory. That brings me, I think, to the other piece of this, which is the theory that was based on the testimony almost exclusively of their expert, Jeff Anderson. And I won't rehash, we had a lot of argument before the trial about why this fellow shouldn't have been allowed to testify, and you would preserve all that. But this part of the award was a $15 million economic damages award, and basically saying that the value of Gawker.com, the one website that published this, increased by $15 million as a result of the Hulk Hogan sex tape. And the facts are, and this we again have to credit his testimony, the facts are that when we asked him on cross-examination, right, did the traffic increase, he conceded that the traffic when the sex tape got posted and the traffic in the month that it was taken down, 6.5 months later, 7 months later, were roughly the same. And he conceded essentially that there was no Hulk Hogan effect. So to say you're entitled to $15 million based on a supposed increase in traffic, where the evidence that was adduced at trial says there was no increase in traffic, that's a lot of money for something that didn't happen. And then the second thing, and we've been over this and I don't want to belabor the point, but the second point is that when he did this, right, he conceded on cross-examination from his review of the data that the Hulk Hogan post accounted for only 0.7% of Gawker's unique page views during that period, or during that year, I should say. But what he was doing was mixing and matching two different statistics, right? When he figured out the traffic generally, he used basically a monthly number, and for how many times people visit the site monthly. So he says, like, oh, that's an increase in traffic. But then when he got to what portion of that was attributable to the Hulk Hogan sex tape, he used views just to that were unique page views. Now it sounds like a lot of internet gobbledygook, but basically what that means is if you're comparing numbers, but you're using two different metrics, you're not comparing apples to apples, you're comparing apples to oranges. And when you do that, the net effect is that changes the number from a 0.7% total traffic, and he says it's a 28% growth over that period in time, which then this statistic tells you, oh, no, it's not, right? So we say here we have $15 million. Now, I would say to you, Your Honor, that probably shouldn't matter in this respect, and here's why. We have a problem of double recovery. And here's why. What you are trying to do on a right of publicity claim, right, you're basically saying the plaintiff infringed, misused my publicity rights, my rights and my name or likeness, right? Again, putting aside the argument that in this context we think that in the absence of a commercial purpose for some other product, like that's Mr. Safir's argument, we've been over that. Putting that aside, the model of this tort is you're basically saying, what are the value of those? Those were taken, and for damages purposes, you're saying, what are the value of those rights? Now, there's two ways to do that, right? I take something from you. Well, let's make it better. You take something from me, right? And I want to know what's that worth. One way of measuring that is, what did I lose? And the other thing is, what did you gain, right? But they're both approximating the same thing. And so what we have here is the $4.95 theory, although we contend for the reasons I just said it doesn't actually do this, is attempting to say what is the loss to Terry Bollea, to Hulk Hogan, right? I didn't get the commercial opportunity that I could have had. What is that? And the value of those publicity rights is what did he lose? The other is Gawker increased its value to the tune of $15 million. The question is, what did Gawker gain, right? You can't have both of those things because they're doubling the recovery. You're basically saying, look, you know, you're going to measure this either by saying what did I lose and what did I gain. Now, it is our position, just so we're clear, Your Honor, that under Florida law, the reasonable royalty rate, i.e. what did the plaintiff lose, is the proper measure, not the what did I gain. And I realize that I'm choosing, if you're going to give them a choice, I'm assuming they're going to pick the higher number between the two anyway. But it is our position that the reasonable royalty is what Florida law allows, not the benefit to the person who took it, largely because that's harder to assess and may include other things, right? So, for example, in the Kaysen case, there was the misappropriation of name and likeness for, and the court said you get the reasonable royalty, not the benefit to the person who used it. And the reason is because it then got used with a product. So if I put, just to use this as an example, if I put Hulk Hogan's image on a box of Wheaties and I start selling Wheaties, if I look at what the royalty he should get on the market, that's an easy thing to assess and to carve out what would he benefit or what would he get, right? If I do the box of Wheaties, I've got to sort of figure out, well, how many people are buying this because of Hulk Hogan's image? How many people are buying this because they like Wheaties? How many people are buying this because it was on sale, right? There's a whole bunch of other things, and it's a more nebulous inquiry, which is why the royalty rate is the preferred. But what is clear regardless of what, which one you pick, is that you can't do both because then you're getting a double recovery. And so it's our position that this ought to be reduced to the $525,000 under a proper application of their own experts' theory, and that the other part ought to go because it's a double recovery. Before I leave that, I just want to make sure, because that's probably a little more complicated than the emotional distress damages. Do you have any questions? Because then I'll move to punitive damages. All right. Lastly, punitive damages. Here, we have a $25.1 million punitive damages award. And if you look at the factors, right, if you look at the factors that are applicable under the case law, they basically break down into two things. One is how reprehensible was the defendant's conduct, and two is their net worths. So if you look at the reprehensibility factors, and I know the plaintiff is going to get up and say this is the most reprehensible thing that ever happened in the history of the universe, but if you look at the factors and you consider it compared to other cases, one of the factors is whether the harm caused was physical as opposed to economic or other non-physical harm, right? He's disclaimed any physical harm relating from his, as a result of garden variety emotional distress, and you have cases which involve, crushed skulls, permanent disfigurement. You have lots of tobacco cases where people develop lung cancer or other illnesses, live with them for a long time, and die a slow, painful death. Second is whether the tortious conduct evinced an indifference to or reckless disregard for the health or safety of others. Again, no physical injuries, so that's not present. Whether the target of the conduct had financial vulnerability, that's not really a factor here. Whether the conduct involved repeated actions or was an isolated incident, right? We don't have a, where we're doing thing after thing after thing to the plaintiff. And whether the harm was the result of malice, trickery, deceit, or mere accident. Now, again, on this last one, it is our position that they believe that this was newsworthy and therefore not the result of intentional malice. And in fact, look, the testimony at trial, there was no, there was lots of testimony that said they weren't out to harm Terry Bollea. There was a lot of testimony that said only that they were not, that wasn't their focus, right, which is different than that intentional. But the other thing about the, so a number like $25.1 million is usually reserved for situations like tobacco cases where the defendants have net worths in the billions, right? So you're really talking about, this is reprehensible, they've engaged in this, years-long pattern of concealing the harms of smoking risks to pad their own profits. There are injuries that last many years and are deeply debilitating physically, and their net worths are many times what Gawker's is, and there you end up with, under those factors, an award that's sort of, in this range. And the net worth factor here is also it cuts in the same direction, and here's why. Even without considering the compensatory damage award, the magnitude of the awards here relative to the defendant's net worth would be among the largest in Florida's history and are grossly excessive considering the conduct at issue, right? So we have here punitive damage awards that are, huge, really outside the tobacco context. And as I said, that's a different kettle of fish, because you have, in that instance, a net worth that is extraordinary. And so if you are permitted to award $20 or $30 million against a tobacco company to deter them or punish them, or, in this case, deter them, and they're worth billions, you can't do the same to Gawker without really it being out of whack. And again, this part of the inquiry is to sort of bring this award in line with other awards. And I stipulate that this case is not a tobacco case, but I would respectfully submit that much as the plaintiff will get up and say both that this was horrible for Mr. Belay and that this was the worst thing that ever happened, that there are in fact actually worse things and bigger defendants by far that where that amount is reserved. And then the last thing I'll say just has to do with Mr. Delario, where there's an award of $100,000 in punitive damages. The evidence was undisputed that he has a negative net worth. And there is case law there's no response to this in their opposition, including a case called Mazzaferro, where not even $10,000 was allowed in punitive damages where the defendant had no assets. And although it's a sort of small piece of the $25.1 million, I do feel constrained to mention the .1 because as it relates to Mr. Delario, that is, and I know the plaintiff is going to say, well, the jury was trying not to do more because they really didn't like Mr. Delario and they took to heed your instruction that they couldn't bring the defendant into financial ruin. But as a practical matter, their award does exactly that, and it needs to be, I think, remitted as a result of that. Unless Your Honor has any questions, I'll sit down and reserve a little bit of time for, move this back, for rebuttal. Thank you.
Thank you. I do just want to start by reiterating, I'm not going to repeat Mr. Turkel's arguments, but we think that there has been a waiver and a clear estoppel here, and we would ask that the court make a specific finding that the arguments that they have just now raised have been waived, that they are stopped. We would also ask the court to make a finding that even if they were not waived or stopped, that this motion should be denied on the merits. The jury's verdict here, Your Honor, was supported by overwhelming, competent, and substantial evidence. The argument that they were swayed by passion or prejudice just ignores what happened at the trial. This jury was stoic, they were attentive, they were engaged, they took copious notes, and they asked pointed evidence directly related to the evidence that was presented. 4 women, 2 men, from different backgrounds. They ranged from ages 23 to 58. They were married, some were single, some were divorced. There was a real estate broker, a security officer, a realtor, a student, an IBM software specialist, and an engineer. Came from all different backgrounds. And they all came together on the decision that they made in this case. There was nothing during the course of the trial that indicated that they were acting under any kind of passion or prejudice. In fact, one of the arguments that's been made is that this whole argument about the punitive damages, that perhaps is the best evidence that this jury followed the instructions that you gave them exactly, which was your punitive award shouldn't bankrupt the defendants. That's why the punitive award was so low in comparison to the compensatory award. They were following the law. And there's no reason to suspect or believe that they didn't do that when they awarded the other damages in this case, or when they found that the defendants were liable. What happened here is that this jury understood and took into account the unique facts of this case, which demonstrated by unrefuted evidence that over 7 million people on the internet watched Mr. Bolea naked and having sex against his will. Over 7 million people. Now, I know in the papers they attack those numbers and say, well, they're based on hearsay. And this is where we're going to start getting into some of the choices issues, but they stipulated to the admissibility of that evidence. They stipulated to the authenticity of that evidence. And then now they want to come back and make the exact opposite argument to this court, which again, they were stopped from doing it and they waived. What this jury did was they put an enormous value on privacy. For the first time, a jury did that. It's not like any of the other cases that the defendants have argued or cited. They cite a few cases involving publications of nudity, but you're looking back at the 1980s. It's not the internet. It's not 7 million people watching someone naked and have sex against their will. The jury understood and appreciated that. You know, we live in a world now where privacy has become much, much more important. Everybody has a cell phone camera. Drones are flying around. This guy wanted privacy in a bedroom while he was naked and having sex. And they took that away from him. And the jury found correctly that there was a very, very heavy price to pay for it. And they were perfectly justified in doing so. I mean, we said this in our moving papers, but if we'd come in here and said to you, you know, Mr. Boulea wants $10 because a person sat outside the window and watched him naked and having sex, he wants $10. No one would have a problem with that. You okay?
Yes, Ryan. Thank you very much. Thank you.
You good? Right. Okay. So no one would be shocked, no one would think that would be from passion or prejudice if that was an amount that was awarded, but that happened to him 7 million times. You apply that reasonable number of $10 to the over 7 million people that saw it, and you're looking at $70 million. It's not unreasonable. It doesn't come close to the standard that they have to establish to get a remitter or to show that the jury had been swayed by passion and prejudice, Your Honor. I mean, the standard we're talking about here, it's in the Brown case. I think that they cite in their papers. A court should not declare a jury verdict excessive simply because it's higher than the amount the court itself considers appropriate. The award will not be disturbed unless it is so inordinately large as obviously to exceed the maximum limit of a reasonable range within which the jury may properly operate. That's citing to a second DCA case. If the award exceeds the maximum reasonable range, it should be reduced to the highest amount the jury could have properly awarded to the prevailing party. Based on the facts presented here and what this jury was presented with, there's nothing unreasonable, irrational, or illogical about the damages that they awarded. A lot of these arguments that they've made are simply rehashes of the same ones we've already dealt with 2, maybe 3 times before. One thing I wanted to point out is they're looking at comparison cases and comparison verdicts. Is that the second DCA decision in Ailes, 41, 7th, 3rd, 10, 22, notes that comparison of verdicts is only one method to consider whether or not the award is excessive. But it also recognizes that no injury is exactly alike. And that's why such comparisons must be made with caution. I would say that they need to be made with extreme caution in this case, because there is no case like this one. It's a first impression case. That's why so many people are here. That's why so many people are watching it. These cases haven't gone to a jury before like this. Certainly not in a situation where over 7 million people got to watch someone naked and having sex against their will on the internet. So really, you can throw all those other cases out the window. You know, it's not a case involving the loss of a child. It's not any other types of cases that they've cited. And we certainly appreciate the arguments that they've made and the comparisons that they've tried to make there. But the facts are this. When someone loses a child, when someone's disfigured, there's me, there's other people here, they can go back to their home. They can slink back into anonymity. He didn't have that option. He didn't get to do that. From the minute he walks out the door, he's recognized. When this broke, when he started realizing that this was out on the internet and people, his fans, were watching him naked and having sex, when he looked into the eyes of fans, men, women, kids, thinking to himself, oh my gosh, has this person seen me? That hadn't happened before. Another big distinguishing fact of this case, even though they try to use this against him, is his job forced him to be in the public eye at that time. Not only did this happen to him, But shortly after it happened, he had to go and do a press tour. That was his job. His job was to go out and promote TNA wrestling. And so while this was happening to him, while he's suffering this incredible emotional distress and the devastation over this, he's got to do it publicly. He's got to go on interview after interview after interview and talk about this. Even though he specifically asked his publicist at TNA, Jules Wortman, please ask them not to talk about it. She said, no, it doesn't work that way. They're going to talk about it. And that's why we made a point of pointing out to the jury, Your Honor, the pain that you could see on this man's face while he was doing interviews. You know, he may have been saying things, talking about certain issues, and if you take it out of context, you can spin it. But when you look at the pain on that man's face, on those clips that we showed, his distress was obvious. You know, and he doesn't, like an ordinary person, to just go back into his house, deal with it that way. I mean, we said this in our papers, but I mean, he had to experience an unparalleled invasion of privacy and an unparalleled form of the internet, which none of these other verdicts are really comparable to. Now, on the economic damages, Your Honor, our damages are supported by unrefuted testimony of experts. Their own experts supported our damages. We talked about this earlier, but you know, Mr. Horn said $100 million advertising campaign draw no visitors to his website. $100 million. That's less than the $15 million that we're talking about here that got them millions of people. Millions. That was their own expert. You know, they complained about the fact over, you know, the value that we proposed to the jury. The $4.95 value for the over 7 million people that got to watch this man naked and having sex with him. That again, that was Kevin Blatt, a sex tape broker. And he testified that that was the minimum amount that someone that would have to pay to watch Tom Sizemore having sex on the sex tape. Licensed sex tapes, Your Honor. That's why this whole argument that they made and that the jury clearly rejected, that, well, you can watch clips for free, those were licensed tapes. People own them. They had agreed to distribution. That's different from Mr. Belea's situation. And I'm sure the jury took that into account, and they have no evidence to establish otherwise. They chose, again, Your Honor, what evidence to present in their case. I mean, they retained Mr. Blatt as their own expert. They retained him to opine as to the value of a celebrity sex tape. Then they chose not to call him. That's their choice. We're not responsible for that. The court's not responsible for that, and the jury's not responsible for that. They retained Mr. Horan to talk about the benefit, the value of the benefit that this thing had. But then they limited his opinions at trial. Again, that wasn't our choice. It wasn't the court's choice. It wasn't the jury's choice. They could have gone out and retained other experts if they wanted to. The whole argument about this being a double recovery, they had experts in each of the areas in which we sought damages, which were the value of the benefit that they got from being able to advertise and market their website, that benefit that was improperly gained, and then the fee. A reasonable amount of money to give this man for all the people that watched him naked and having sex. And it's not comparable to other situations because it was done against his will. It's not a double recovery. It's two completely different types of damages. That's why they themselves retained different experts to talk about them. They just chose not to present that evidence and that testimony at trial. Another interesting issue, Your Honor, with the choice that they made was, if you remember, we wanted to break these down on the verdict form. We had these separate categories, so it would be a little bit more clear what the jury was awarding for what, and they objected. So it ended up being one category, and they stipulated to that. And now they want to complain about the amount that the jury awarded. At the end of the day, damages in tort cases are supposed to, and this is what the jury was instructed on, fairly and adequately compensate someone for the losses that they sustained and the injuries that they suffered. That's what the jury was instructed on. That's what they found. There's absolutely nothing in the record, no argument raised that would suggest otherwise. These arguments about garden variety, I think they've all been made before numerous times. At the end of the day, garden variety in this context, it's the same emotional distress that would compensate someone for the type of emotional distress that a typical person would experience in this situation. That's what it is. It's not synonymous with nominal. And again, there have not been comparable cases like this one. And I'll finish up, Your Honor, dealing with the punitive damages award. It's interesting that they note that the most important factor, the most important consideration there is the reprehensibility of the conduct. And Mr. Boleyn said, well, I know they'll get up and say it was really reprehensible. I'm not going to say that. The jury said that. It's kind of being lost in all of this is what they're making their arguments. They're not actually talking about the fact that they're asking you to overturn a jury verdict. The jury made these findings. The jury found that what they did was utterly intolerable in a civilized community. It was malicious, that they had a specific intent to harm. The jury found that this was extraordinarily reprehensible. It had violated community morals. That it violated common decency that's recognized in Toffoloni. And it was done on the world stage. In a forum where it never really goes away. In a forum where over 7 million people got to watch this man naked and having sex without his consent. They found that it was extraordinarily reprehensible. And despite that, contrary to the arguments being made that they were swayed by passion and prejudice, they limited punitive damages. It was a fraction. And we have the figures in our opposition, Your Honor, but it was a small fraction of the compensatory award. And as to the $100,000 against Mr. Giuliario, one of the jurors actually asked, can we give him community service? Because they didn't want to bankrupt him. Now they try to say, well, that shows that they wanted to punish, it's a criminal type thing. That's what punitive damages are. They wanted to punish the man for what he did, but they wanted to follow the law. And that fact is extraordinarily telling as to what was actually motivating this jury, whether it was passion and prejudice or following the law. And it's kind of insulting to them to suggest that, given the way that they ruled on punitive damages. And I don't know, Your Honor, I mean, with respect to Mr. Giuliario, I mean, the law says that a punitive damage award can't bankrupt a defendant. Well, if he has a negative net worth already, I don't know. I honestly don't know. I didn't see a case on it, but I don't know if then it's the punitive damages award that is actually bankrupting him, the $100,000, or if he already is. It's an interesting issue. There's a lot of interesting issue with respect to the punitive damages because it's a very unique situation. The compensatory damages were high. But at the end of the day, I think the ultimate result on all of this should be exactly what Mr. Berry said to the jury. We owe, and we must pay this money. They should be held to that, whether it's through waiver or estoppel, or under the law, saying that we don't set aside jury verdicts unless something really, really bad and really, really wrong happens. And none of those things have been demonstrated here. So we would ask the court to deny this motion and make the findings that we requested.
Would you like to make any comment as far as the specific economic damages, the difference in the $50 million versus $50 million that Mr. Berlin pointed out?
I'm sorry, I didn't hear you.
$50 million versus the $55 million, that aspect of the economic damages that Mr. Berlin pointed out. Would you make a specific comment?
The only comment that I'll make on that, Your Honor, is that we proffered evidence to the jury as to what the minimum amount would be to watch someone naked and having sex. They're free to accept that. They're free to accept our expert's version. They're free to accept their expert's version, or the law says that they can come up with their own number. Because at the end of the day, what the law says and what they were instructed on by agreement of the parties is you give him an amount that will fairly and adequately compensate him for the damages that he suffered. They could have said, we think it's a little higher than $495. I mean, the testimony was that's the minimum amount you would have to pay. And there was also testimony from the experts that, look, this is what the view counters say. It could be more than that. I can't get inside their thought process, obviously. The Gawker defendants didn't ask to interview them, even though they could have, to flush out these issues. It's a lot of speculation that really there's no hard, firm evidence of them being persuaded by any passion or prejudice here. So we'd ask that it be not.
I'll try and be brief, Your Honor. Let me first on this waiver estoppel point, I'll just rely, if I may, on what we said in our papers and what Mr. Brannick said earlier today. On that point, I think that what we said was both appropriate and, for what it's worth, not misunderstood by the jury. I mean, we didn't bring in press conference. They did a number of press interviews afterwards, but they made a point of saying and acknowledging that they understood that there was going to be an appeal, and you do that only knowing that when somebody says, you know, this is the amount that you've told us to pay, or we must pay, or we owe, that's what you're operating.
I think in their moving papers, they raise a case that says you should not be taking in the jurors' post-trial statements into consideration.
I was only
noting
what they put in their papers. We did not put any jury comments, and just to make that clear, and I'll be happy to move on. With respect to the actual numbers, let me just go through them. I would, on this punitive damages point, you know, this garden variety emotional distress, we don't get from $100,000 to $60 million based on some generalized notion that that's what a person might have experienced if that had happened to them. That's not what the law allows. That's something that the courts routinely require proof on, and that's why we've asked you to remit this from $60 million to $100,000. If the court is not inclined to do that, we still believe that the $60 million is way out of whack for any of the other compare with any of the other cases. And again, that's not information the jury has, that's information that you have, but the implication is, you know, of Mr. Vogt's remarks about this is the, you know, this case is unique and he suffered a grievous invasion of privacy that lingered on. There are lots of injuries in the cases that are equally if not worse, equally bad if not substantially worse, that do linger on for people, and that the courts have not come anywhere near awarding that kind of money, including in cases where there are, you know, things that linger on that result from publication. We cited an example of the largest jury verdict against a media defendant in Florida was, I think, $18 million and promptly reversed. But there was, again, the thing where it's disseminated widely and you have that same lingering effect. So that just has to be reduced, and I think that $60 million has to come down. On the $55 million, the issue isn't just the jury could have thought this and the jury could have thought that. This is an economic damages claim, and the jury's verdict has to match the evidence. It can't just say the jury's free to disregard the evidence and say, well, we think it would have been different, or we think it should have been $10. They offered proof, not saying this is just some number that we picked out of the air to say, here's what a reasonable person might get for an invasion of privacy of this magnitude. They came and said this was a lost commercial opportunity, and they based it on an expert who came in and said this is what the fee would be and these are what the numbers would be. I do just want to say quickly that we did not stipulate to the admissibility of the counter numbers that Mr. Shun relied on, and we objected to that vigorously, in fact, in our Dalbert motion. preserve that objection. So I just want to be clear about that for the record. But this $55 million number, they presented evidence to the jury. They came up with a very exact number of what that evidence came to. It was, the jury awarded 4.7 or almost $4.7 million more than that. And I didn't really hear Mr. Vogt to address in any meaningful way the point about the double recovery, right? This is you could either get the lost benefit to him, or you can get the benefit to us. But if you get both, you're basically double recovering. I assume they will pick the higher of those two numbers if your honor is not otherwise remitting those for the reasons that I said. But that would be, at a minimum, it would be a reduction of 4.7 for the part that wasn't proven at all, and 15.4 for the part that was duplicative. Lastly, on the punitives, your honor, let me just say one last thing before I get to punitives about that. This bit about the $4.95 theory, Mr. Vogt went on at some length saying we put in no evidence to establish otherwise. We chose what proof to put on. They also chose what proof to put on, right? They could have come to the court and said, here's testimony that of that $4.95, here is what an individual celebrity would have gotten from being part of this library that a person is being accessing and paying to access. And they did not do that. And so there is no proof in the record from which to support the jury's verdict. So I'll just add that additional point. On the punitive damages, what the jury doesn't have in front of it is other punitive damages award that bring this into line with one another, right? So what the jury says is we find this reprehensible, and even assuming that it properly looked at the reprehensibility, which we dispute for the reasons I said at the opening, and even assuming that it took into account the net worth, right, it still has to be brought into line. And what we have here is the only awards that are in that situation are awards where they're against tobacco companies, which are worth, billions of dollars as opposed to millions of dollars, and that tells you, plain and simple, that this is out of whack. And then lastly, with respect to the $100,000 from Mr. Delario, as again, Mr. Vogt said he didn't really know and he's not aware of a case. We cited a case where there's even $10,000 was improper for punitive damages for a person with no assets. And I realize that's frustrating to a jury and perhaps to a court where there's some impetus to impose punitive damages, but that is the law. You can't impose a punitive damages award that would ruin the defendant financially, and that's what this would do, and that also needs to be remitted. And I think I'll stop there unless you have any questions.
I don't. I want to take just a brief break because I need to check something, and then I'll come back, and then I may have a question after that. So
Very well, Your
we're
Honor.
going to take our lunch break at 4:00, so this is just a very brief break.
All right, we'll stand by.
All right.
Check, 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 check.